two Ghanaian nationals have asked the International Criminal Court to examine what they term years of xenophobic violence in South Africa, arguing that repeated attacks on foreign nationals could amount to crimes against humanity. Well, for analysis on this, we're joined by a professor of international law at the University of South Africa, UNISA, Professor Angelo Dube. Prof. Dube, good evening. Thank you so much for your time. Really do appreciate it. Is this such a complaint within the ambit of the ICC?
Good evening, and thank you for having me. The situation we're presented with is very, very interesting in the sense that we see two individuals running to the ICC, claiming that certain elements or certain actions that have taken place in South Africa amount to crimes against humanity, which essentially they are trying to say these are international crimes and therefore place them within the ambit of the ICC. Unfortunately, it is not a straightforward matter like that. They have approached the Office of the Prosecutor with this information. That does not mean that South Africa is being investigated. The simple handing over of information to the Office of the Prosecutor means that the prosecutor must look at that information and decide if in his own judicial assessment, or his prosecutorial assessment, he thinks there's a case to be answered, at which point he can then ask the pretrial chamber to have a look into South Africa. But he must go to the pretrial chamber having satisfied himself that the information that is presented with does indeed present a strong case for him to look even deeper. So to answer you, the short answer to that is that at the moment, the movement of these complaints to the ICC is not really justified.
Yeah, my understanding is, Prof, and do correct me if I'm wrong on this, that the ICC investigates juristic bodies and juristic actors, that is to say individuals acting on behalf of the state rather than the state itself as a singular body. Am I understanding that correct? And if so, surely the two Ghanaian nationals should have, in their complaint, identified to the ICC who the individual actors are that they think ought to be prosecuted. Am I understanding that correct?
Correct. Unfortunately for them, to rush to the ICC a week or so after a match in South Africa would not have given them enough time to investigate and not just rely on anecdotal evidence that they pull off from the internet and then run there with it. Because before you go to the ICC with such a complaint, you need to have been on the ground, talk to human rights bodies, talk to the state itself, talk to various functionaries on the ground, and as well as victims and other witnesses, and then take that information to the prosecutor, knowing who are the likely perpetrators in this instance. You can't just go there and blame the state of South Africa, because it wasn't even the police that are accused of doing anything, or our soldiers perhaps, or any other state functionary. You are correct that it's individuals who can be brought before, or perhaps let me just say legal persons in the words of the law, who can be brought before the ICC and not the state itself. So the matter is rather intriguing the way it is being approached right now. It does seem like it's a group of two individuals who are seeking relevance in the current geopolitical space right now, using whatever is developing at the international level.
Yeah. And just finally, the evidentiary matrix that would be under consideration, upon who is the onus to submit evidence? Is it on the complainants, that is, or is it on the ICC to investigate?
To allow people to just make allegations without necessarily providing evidence, the system would become, would allow for frivolous accusations, and we cannot afford that. So whoever takes the matter to the ICC ought to point the ICC in the right direction, to say, here are our sources of information. Here is where you're going to find evidence of what we're complaining about. The other issue here is the issue of complementarity. They cannot run to the ICC when South Africa has courts which are capable of dealing with any matter complained of. They have not approached South African courts to try and resolve this issue. They've run to the ICC as a court of first instance, and international law frowns upon that. It not only does it frown, it does not allow it to happen. It shouldn't be happening. You start with your domestic remedies unless South Africa is unable or unwilling to prosecute these particular matters. Then you can jump to the ICC. But as it is now, they've jumped the gun. They have not followed the prescript of the law in as far as complementarity is concerned. And on the basis of admissibility, they will not. This matter will not be entertained by the ICC.
Yeah, we're going to have to leave it there. Thank you so much for your time and your insights on this. Really do appreciate it. That is Professor Angelo Dube from the University of South Africa, UNISA, international law professor there.